All right, so we'll go ahead and get started. And if anyone joins late, I'll be sure to admit them. Hello, everyone. My name is Caroline McLean. I am the project manager for Rocky Mountain Reach. And today I am here to introduce Zach Scott, who is the Associate Vice President for Research Compliance and Technology Transfer at the University of Montana. And I'll let him speak more about his experience, but Zach is here to kind of give an overview of intellectual property essentials and technology transfer, and in broad terms, like what that might look like for your projects. So thank you, Zach. I appreciate you joining us.
Thanks, Carolyn, and thank you for inviting me to present today. I'm pleased to join everyone. Can everyone hear me well and see this? They see the slide deck that I'm broadcasting. Everyone's good. Thank you. So yeah, I run the tech transfer office here at the University of Montana. By training, I'm a former research scientist. I was an immunologist through 4 years of postdocing, and then I decided to do something different with my life and went into patent law. So I'm essentially a patent attorney, and I work here in Missoula, Montana, and I'm very privileged to work with some great research faculty here and their associates in protecting the university's intellectual property. Before I get started, I wanted just to invite people. I imagine that you are coming from different experiences with intellectual property. Some of you might be quite seasoned in developing your own IP. Others maybe haven't done it at all. And so I would just encourage you, please, feel free to interrupt me and ask questions as I progress, or leave a chat. Carolyn's going to monitor the chat room and interrupt me if you drop a note there. I just like to try to make this as broadly interesting for everyone here as possible, given the probably the likely broad range of experiences. I'm also going to move through these fairly quickly, so please again ask me to hold up if necessary. So what is intellectual property? Generally speaking, at least in the United States and most of the developed world, I should say, we can broadly break it down into four components. We have copyrights, trademarks, patents, and then trade secrets. In some ways, trade secrets is a catch-all. It's in some ways also the most simple to understand. It's just something that people keep as secret. I'll talk a little bit more about that in depth. I will be spending most of my time in today's discussion talking about patents, but I will provide some brief overview of copyrights and trademarks. I think most of us in our daily lives are somewhat familiar with these different concepts, but how they apply to research, especially in a higher education context, is the purpose of today's talk. So again, the four pillars of intellectual property, we'll start with patents. What is a patent? I'm going to read this. A U.S. patent gives the patent owner the exclusive right to make, use, and sell the invention in the United States. Does everyone agree with that concept? Anyone have a problem with what I've written here? Sometimes my law students pick up on this. This is wrong. This concept is wrong. Most people will describe a patent as more or less a monopoly right granted by the government. But there's a very important distinction I want to make here. A patent is actually a negative property right. It is the right to exclude others from making, using, selling, or importing the subject invention, generally for a 20-year term of exclusive use, or the exclusive right extends for about 20 years from your non-provisional filing date. It's protected by the Constitution, and it is not a monopoly right. The point I'm making here is that you can only exclude others from using that invention or practicing that invention, but it doesn't necessarily mean that you yourself have the right to practice it. This is a difficult concept sometimes to understand. So if I was to rewrite that first sentence, exclusive right to exclude others, how does this work in practice? And so I have my Flintstones scenario that I think tries to get across this point. Imagine two cavemen at the beginning of time. Fred invents the wheel and he gets a patent on it. There's amazingly a patent office in prehistoric times. And it's a round disk that rolls about a central axis, and we're going to call that element A. His friend Barney invents and owns a patent for a wheelbarrow, which of course comprises a wheel, element A, connected to two wooden handles and a box. And those new elements that Barney has invented are element B. So the question is, can Fred make a wheel without infringing Barney's patent? And I think everyone can intuit the answer is yes. This is the beginning of time, after all. There are no other patents. This is patent number one. And so I can get this to advance. Yes, he can make a wheel. No one else holds a patent on the wheel. There's no one excluding him from doing that. But here's where things get a little bit tricky. Can Barney make a wheelbarrow without infringing Fred's patent? The answer is no. The wheelbarrow comprises in part element A, the wheel. So in order for Barney to be able to make a wheelbarrow to sell it at the local caveman shop, he would have to get a license, or he'd have to buy that patent from Fred, right? And then the last point is, can Fred make a wheelbarrow without infringing Barney's patent? And the answer is likewise no, right? Barney holds the patent on the wheelbarrow, even though it incorporates his wheel, again, patent number one. Barney still holds the patent on the wheelbarrow concept. And so this, I think, is the best way to try to explain how, even though you may hold a patent right on an invention, it doesn't necessarily mean that you have the right to practice that invention yourself. You have to look back in time to see if somebody else holds a patent right over some component of what you're practicing. So what are the statutory requirements to get a patent? I'm going to try to cruise through these pretty quickly. I'm not going to read everything, but there's generally 4 different hurdles that you have to jump over to get a patent from the USPTO and frankly, most of the other patent offices in the world. They're very similar. It has to be useful, not something that gets examined really that much. Most people that are investing the time and money to make a patent application, it's presumed that the subject invention is useful. Where we really get into a lot of disagreement, however, with the patent office is whether an invention is novel, is non-obvious, and whether it is actually subject matter eligible, right? It also has to, the patent filing itself, the application has to sufficiently describe and enable the invention such that a person having skill in the art, so not someone off the street, but someone who practices within the art field. So if you're talking about a new medicinal chemistry application, like a new compound, the application would have to enable that kind of person, likely a PhD in medicinal chemistry, to be able to make the compound and then use it in the way that it was intended. Obviousness. This is really where this is where private practice patent attorneys make their money. And that's, as I say here, this is where the battle was waged. There's a funny Dilbert idea where the no-click shopping idea, kind of like an Amazon type thing, it's likely an obvious type of invention. If you think about it, obviousness requirement for a patent is kind of a silly or an absurd concept because it's a subjective concept. And the very purpose of laws is to tell the citizens of a country what they can and can't do. And so they need to be very objective. I think at the same time, we all intuit that we don't want patents issuing in over inventions that don't appear to be really adding to the value or adding to the function of something that came before, right? We don't want a patent issuing where someone's invented paint and then someone else comes along and invents like red paint, right? Like they've added a pigment to something. It would have been an obvious improvement on what was already existing, but it doesn't really move the entirety of the invention corpus forward. And so how this works out with respect to the types of higher education type claims that come before. I mostly deal with biochemistry or pharmaceutical type claims. And so it really comes down to case law and looking for examples in the US case law where we can show that different, for example, substituent groups on different chemicals may have non-obvious functional or biochemical properties. And so that's the beauty of being a patent attorney, is like you have to think, it's like 50% lawyer, 50% scientist. You have to be conversant in both to be able to move your client's invention forward. Who gets a patent? Patents are granted to inventors. This is true in higher education. So an inventor is someone who conceives of an idea. That's the the light bulb above your head moment, and then reduces it to practice. Reduction to practice can actually, it can be what's called actual, like you make the new part in your garage or in your laboratory, or you synthesize the chemical, for example, in your laboratory. Or it can be constructive, and that is you simply describe how it's done in a sufficiently enabling way that someone else could do it. Typically, reduction to practice occurs constructively. It's not entirely common that that's done before the patent application is filed. So the patent application itself serves the role of reducing the invention to practice. An inventor must have contributed to the conception step. And this is a very common problem that I see in higher education, because as scientists or researchers, we're very, we think about publishing and what are the sort of norms and standards of what comprises authorship in a peer-reviewed journal, for example. These are not the same standards. And so it's very common that you might include a collaborator or a student, a postdoc, et cetera, as an author on a paper, but not include that same person as an inventor. They have to have contributed to that purely intellectual component, where they conceived of the inventive or the inventive element that you're describing. Again, please raise your hand, yell at me, leave a chat note if you would have any questions as I go through this. What is a patent or a patent application? Well, it's a document, as some of you may have seen them. It comprises a specification. That's the written description component I've described. It also has claims, and the claims are, for lack of a better way of describing them, it's kind of like one of the old time like real estate or real property descriptions. It's like it's 100 steps to the north, and then to the apple tree, and then 100 steps to the west to the fence line. Well, it's the same idea. You're trying to define what is the scope of your invention so that some third party, like anyone else in the world, would be able to see what is the patent right that you are claiming. As I said, I do a lot of chemistry or chemicals. So frequently it's going to be the broad claim is going to be a chemical formula of our invention. And then we will narrow it by further defining various substituent groups or species. If it was a machine, we would describe it, perhaps the most inventive element, as a broad claim, and then we might add components in detail to narrow the scope. So they can be, inventions can be directed toward compositions of matter. That's what I've been discussing mostly, or machines, but also articles of manufacture and processes, method claims. And so method claims can be very helpful. It can be a method of treating a patient who's suffering from a condition. It could be a method of synthesizing a new compound. So method claims are also very important, especially in the United States. This is an example of a claim that I wrote. Sorry, and just to illustrate this, I don't know if any of you are chemists, but all patent claims kind of look the same in the sense that they just try to describe broadly with the first claim. It's an independent claim. What it is you're claiming, and here what we can see is the chemical formula with different substituent groups, R1, R2, R3, and then R1, R2, and R3 are further defined as comprising different chemical moieties. So if you look at this and sort of digest it, what you realize quickly is that by this one formula, we are actually describing potentially thousands, tens of thousands, perhaps even millions of different compounds. And that also becomes an issue in itself, because you may have only synthesized a half a dozen of these or something at the time the application is filed. Where? Well, in the United States, we submit our patent applications to the USPTO, which is a subunit of the Department of Commerce. It's in Alexandria, Virginia. And that can be done by inventors, also called, that's called pro se process, but more commonly it's done by a patent agent or an attorney. Within higher education, typically faculty members or other associated inventors will submit invention disclosure forms to their tech transfer office, and then the tech transfer officers will do some diligence on that invention disclosure, and then if they desire to proceed, they have existing relationships with attorneys, outside attorneys, private practice attorneys that will submit and prosecute those patents. On the other side of the table, at the U.S. Patent and Trademark Office, you have your patent examining corps. So these are generally scientists or engineers. They are highly competent, and they are recruited from industry and academia. So they generally, if, like in the chemical arts, for example, or biological arts, they are generally PhDs. I said that they're in Alexandria. No, actually, they're not. They're actually all around us. I'm here in Missoula, Montana, and I'm aware that there's at least a few patent examiners living and working remotely for the USPTO in Missoula, Montana. I think that was exacerbated, of course, by COVID. But they are, I think they tend to spend a year or two sort of learning the ropes in Alexandria before they're allowed to go back home, so to speak. When? This is important. Generally speaking, a patent application should be filed as soon as possible to avoid losing the patent rights to other inventors that may independently, conceive of the same invention. We've probably all had that moment when you think of, just in your life, like, I have this great idea, and then you Google it and find out someone else had it before you, right? When it comes to the subject matter of your research, you were generally more, as scientists, we're more informed about like what other research groups are doing and what the state of the art is. We read the literature. So that's not usually as likely to happen. But you also don't know what your peers are doing because these things are kept secret. And that's a very important thing, because I'll get to this a little bit later, but in the entire world, if you publish, and that means any disclosure, a conversation in the hallway, even any publication of the invention before the patent application is filed, is an absolute bar to getting a patent right in that invention. There is one exception to this very hard and fast rule, and that is in the United States. Thankfully for us, we have a 1-year grace period. So I'll get to that 1-year grace period. But generally, it's better to really keep new inventions as secret until at least that first patent application has been filed, so that we don't lose rights anywhere. The United States is not the only commercial market in the world. In fact, it's quite a large one. Individually, it is the largest one, but depending on the invention and the appetite of other countries for that invention, you may be leaving a lot of commercial viability off, on the table by doing that. So we generally look to non-disclosure agreements or confidentiality agreements, as well as early patent filings, to try to protect inventions from that legal disclosure that could be invalidating to a filing. I'm just going to keep cruising through here. Why there's strategic tools, why we want a patent. Well, again, it's to preserve the possibility that the invention that you discovered can be practiced and potentially recoup the research costs associated with it. This is especially true in the chemical arts. And any invention, biological or chemical, new drugs that are subject to, for example, FDA review. You guys probably are aware that FDA review is, it weeds out a lot of drugs that at first glance appear to be have therapeutic benefit. And so the costs associated with that can get into the billions. And no company or series of companies, as it usually is going to invest the money and time and the risk in shepherding a new pharmaceutical, for example, through FDA review, if there's no promise of being able to recoup those costs with a patent once they gain approval. And so it's very unfortunate, but occasionally you'll read about new drugs that are developed, but because of either deficiencies in the way that their patents issued, or if they fail to get a patent, they become these kind of zombie drugs where they have a therapeutic benefit, but no one's willing, because of the lack of patent rights or strong patent rights, to be able to shepherd them through that very expensive FDA review process. So that's one reason, or at least an example, that it's so important to try to pay attention, especially in the earliest moments of a new invention. This is a very busy slide, and I don't want you to become overwhelmed. Like, this is generally a description of what we call patent prosecution. So that's the time from the time that an application is filed with the USPTO, in this case, the US Patent and Trademark Office, up until the time that the patent is granted. We have something in the United States called a provisional patent. It's kind of, you can think of it as a placeholder. It gets you a priority date, but you must file what's called a non-provisional application within 12 months. And then if we look at this upper route here, it will usually be about 2 years before that patent examiner I described earlier will do substantive examination of the specification and claims, and then look through the prior art, everything that came before your priority date, to determine if you meet those 4 hurdles: utility, novelty, non-obviousness, and subject matter eligibility. And if you are able to convince the examiner that you meet all of those requirements, then your patent will grant. This period of time can range from maybe a year at the minimum to, I mean, I've seen active prosecution ranging as long as 7 to 8 years. And of course, time is money. The longer it goes, the more mostly attorney expenses you're going to have. And it starts to really eat into your patent term, because your patent term starts tolling on your non-provisional filing date. There is another way that is very common in the United States to proceed with a patent filing, and that is, instead of or in addition to filing a non-provisional application, we can also file what's called a PCT application. This is also commonly called an international application, sorry. And what that does is it sets the stage for easy what are called national stage filings in almost all foreign countries, at least all of them that have functional patent systems. And so, for example, if a tech transfer officer is particularly enthralled with a new invention and wants to protect it in, for example, in Europe and Canada and Japan, et cetera, then he or she is likely going to elect to file a PCT application. And then it more or less serves as a conduit, a unified conduit into all of these other national patent offices. So you can also elect the United States, as you see in this example. But eventually you will have to hire attorneys in those nationalities to prosecute and get your patent to grant in each of those nationalities. So you can very quickly understand that the costs associated with going through a PCT application and then proceeding in other countries can quickly, I mean, it's basically like an exponential cost growth. The cost associated with a US patent for a simple invention might be in the 20 to 30,000 range if you have an easy time of it. And then just start multiplying for each of the other national phases. But indeed, because you've got foreign associate costs, and in some cases, Japan, in some places in Europe, Mexico, for example, you're going to also have translation costs associated with those filings. And so, Japanese applications through to patent grant can easily be $50,000 to $100,000. What does a patent give you? Well, it gives you some remedies. Of course, you can file a patent infringement lawsuit against someone. Those are usually preceded by, cease and desist letters, asking people to cease making, using, selling, importing, etc., the claimed invention. There's also some risks, of course, and that is someone who's accused of infringing your patent is almost certainly going to, if they decline to license that patent from you or to cease that activity, they will probably try to convince the court or the patent office. There's routes to do this in both places to find that the patent was not granted properly, that it's unenforceable. And that might be because there's some prior art that the patent examiner missed, or that the inventor didn't provide to the examiner at the time that the application was filed. Generally, I don't want to spend a lot of time on this. I want to be cognizant of our time. An invention does have to be patentable. This is the patent's eligibility question. It used to be sort of this broad thing. Anything under the sun made by man was patentable. This is definitely no longer the case. It was very quickly determined that sort of natural phenomenon, or physical laws such as Einstein's E equals MC squared or gravity, etc., these are not things or subjects that should be patentable. And more recently, about 10 years ago, it was the US Supreme Court determined a very important case called Myriad, where the genes associated with breast cancer, BRCA1 and 2, had been isolated, cloned by Myriad Genetics, and then were being used to sell a testing kit. And the court found that the isolated DNA of a human, without further modification or without any further change or inventive element, was not patent eligible. It was not a, quote, product of nature. A cDNA isolate, which is a further processing of those genes, is not a product, and that was patent eligible. But the sequence alone was not, and that patent was invalidated for that reason. I'm going to go very quickly through the other areas of intellectual property. I do think it's important to have just a very brief background in these, because it's very easy to confuse these. In fact, I find faculty members very commonly confused. People come up to me very excited, and they tell me they have a new invention to patent, and then I very quickly realize that they're actually talking about a copyright or something. A trademark is a source identifier. We're surrounded by them: Coke, Pepsi, Xerox, Apple computers, etc. They exist at common law, which is to say, they're, unlike the patent example that we went through, there is no absolute requirement that you have to register them or have them examined. However, you can do that. It is the US Patent and Trademark Office. If you choose to register your trademark, and that's where you see the circle R commonly on products, it does give you certain legal rights and presumptions if you did have to bring a lawsuit for trademark infringement. Trademarks are also territorial, which is a little bit of a harder concept. If you practice a trademark without a registration, you only get those trademark rights to the extent that you are actually having commercial activity. So here in Montana, if I had a business selling some type of widget, I would only have trademark rights in the area where I was actually making sales. I'm just going to skip that. I'm going to skip this as well. We don't want to get too deep into trademarks. I do think it's important for people that are in higher education to understand the difference between like protecting an invention and also protecting your source identifier with a trademark. Very frequently, at least at University of Montana, inventions discovered at the university can be licensed to companies. In some cases, the inventors themselves are the principals at those companies, and they operate under conflict of interest rules. And then once they're out or they're wearing their sort of business hat, they really need to understand that their business needs to operate with some type of source identifier. And so that's where they'll maybe take their first steps looking at trademarks. As I have already mentioned, you can, by having a trademark either at common law or registered with the USPTO, that does give you some certain legal rights that you can assert against others that are seeking to confuse that source identifier. Copyrights are also important to understand. Copyrights protect a creative expression that has been fixed in a tangible medium. I think most people are aware copyrights cover things like music, recordings of music, obviously artwork, literature, books that you would buy. Authors have a copyright in their works. It has to be a creative expression that is not derivative of somebody else's prior creative work. And so, for example, if I took the Mona Lisa, for example, Da Vinci's Mona Lisa, and just sort of like recolorized it or tinkered around with it a little bit in sort of some sort of like strange pop art way, there would be a real question as to whether that was a derivative work or if it was actually a new creative expression. There's some interesting case law pertaining to Andy Warhol. Maybe some of you have seen Warhol's photographs of famous people. I think the really famous one is Marilyn Monroe, where he took some some pre-existing photographs that were taken by somebody else, and somebody else had a copyright in, but he blasted out the colors. Like she's like a platinum blonde, and they're very distinctive Andy Warhol works. I actually can't remember which way that case went. I think they were deemed to have been new works and not derivative to the legal extent. And then the last thing I'll say is software is the rare confluence between patent and copyright law. So there are elements of software, if we think of the code, where you could protect that as a method. You recall one of the types of inventions that you can protect is a method claim. And a software is basically an algorithm or a method that happens sequentially. But there's also precedent to protect software in terms of copyright, because others have argued and succeeded in making the argument that it is actually the function of the software is more or less a creative expression that changes some input to a new output. And then finally, very briefly, trade secrets. We are not surrounded by trade secrets, at least to our knowledge, but they play a very important role. A trade secret is something that's recognized by law. It's generally there is some federal law on point, but it's generally a state law device. And that is someone who has a secret. They have to take affirmative steps to ensure the secrecy of what it is they're protecting. And so by the course of performance, the way that they don't disclose, or that they keep any disclosure under a confidentiality agreement, you can protect something that might otherwise be amenable to a patent or even perhaps software. As a copyright, you can keep it from being used by others. The most common way trade secrets are used in our lives is almost certainly through source code encryption of software. So right now we're using Zoom. I'm using Microsoft PowerPoint to show these slides. Both of those are software packages that have source code, but in both cases, that source code is encrypted. I do not have access to it, and I would have to break the law by hacking it to get out that source code. Other more sort of mundane examples would be like the Coca-Cola recipe is rumored to be held in a safe somewhere that only like 2 people know, right? The other fun one is like the Colonel's secret chicken recipe, right? I'm not sure if it's secret anymore, but they do make a big deal out of these like sort of recipes, like keeping them a secret. And the reason for that is that recipes are not recognized as being patentable. There's case law on that, I think, all the way from the Supreme Court from a long time ago. So they keep these sort of recipes as secret. And then it's the sort of the modern day version of that, of course, is software and source code encryption. If someone was to steal your recipe, now it starts to feel like a criminal act, and indeed, that's a lot of times where it can end up. But you also do have some of those same legal remedies that you might find with other types of intellectual property that we've discussed. So one thing that we talk about, especially to like university faculty that might be starting on their own, I cannot give them particularized legal advice, but I can tell them when they think about protecting their business and their intellectual property, we hear sometimes about an IP thicket, and what that is you want to surround your business and its assets, which frequently its sole valuable asset might be a patent application. You want to surround that by barriers to others being able to either take or to trespass on your rights, right? And so we talked about patents, copyrights, trademarks, and other contractual ways to protect, like such as a non-disclosure agreement. And all of those things in combination can make it difficult for others to disrespect your contributions, and also enable you to be able to make investments and to take risk with some some possibility that risk will be reimbursed with success in the future. So the last part of my talk before we open to questions is what is the tech transfer office in all of this? I've already alluded to it to some degree, and some of you perhaps have experience working with your own tech transfer offices. Tech transfer offices are largely born of the institution's duties to federal sponsors. I assume at all of our institutions that are represented here that you're receiving federal grants, awards, contracts, etc., or you're receiving federal money that might flow through state entities, for example. Regardless, we have a duty to protect the fruits of taxpayer-funded research, largely through filing of patent applications. Before 1980, a faculty inventor was largely able to file patent applications in his or her own name and then enjoy the commercial proceeds of those taxpayer-funded research projects personally. And that became a particularly sore point politically. And in 1980, we have the Bayh-Dole Act. And the Bayh-Dole Act, the central premise of that is what I just said: the fruits of taxpayer-funded research should flow back to the common good. It should not just be a person, like a public risk that results in a private reward, but rather that the public investment, if it develops into something commercially viable or useful, that there should be a public benefit that flows from that. And so what that means in detail, or in fact, is that a university who receives federal funding is responsible for doing the due diligence on new inventions, for filing patent applications and trying to protect those inventions through the US and foreign patent systems. And then if there is commercial success that realized on a license of those patent rights, those commercial proceeds flow back to that university and are reinvested in other avenues of research or in other elements of the university. So the universities are really the big, we're the beneficiaries, of course, of the Bayh-Dole Act, but we also have many obligations placed upon us by that act of 1980. And the tech transfer office is largely the conduit to respect both of those, the duties and then the rights of Bayh-Dole. At the University of Montana, and I don't want to cause like any type of uh, anger by comparing ourselves with other universities. At we have a very generous, and this is allowed by Bayh-Dole, we have a very generous revenue sharing policy with our research inventors. They get 50% of any cost recovery once we've recovered our own prosecution expenses. And so that's a great incentive for university researchers to make new inventions, to report those through invention disclosures to the tech transfer office, and then to support the prosecution and commercialization of those inventions. They have a personal financial interest in seeing that that's done. There are universities at the other end of the spectrum, like I know there are universities that don't have any revenue sharing at all. And so I would say it's more common, maybe not quite 50%, but something approaching 50% is what you might see. So we handle the relationships with the patent office and our outside attorneys. The tech transfer offices are also engaged in the commercialization of new inventions, and we largely look to do that through licensing agreements. Those licensing agreements can be exclusive or non-exclusive depending on the nature of the invention and the patent applications. For example, I've recently completed some licensing agreements where it was a method of treating essentially ear infections, and the human treatments will have to go through FDA review. And so it was wise to hold out the application of essentially the same invention for veterinary use, which does not need to go through FDA review. And so we license those components, human use versus veterinary use, to different licensees. And that makes it a much easier, it made trying to sort of commercialize that invention much easier to do it that way. And so I think this is my last slide. Thank you for bearing with me and for your patience. I have my free pro tip here, and that is, as faculty, inventors, or researchers, please contact your tech transfer office very early in the course of your research and in the development of a new invention, so that they can guide you on how to proceed with navigating the patent system and how to proceed with navigating your disclosures to other parties that might be very helpful to enabling your research, or might be research collaborators. I mean, we're within university research system. It's more common than not that you have collaborators at other institutions or even with private businesses. And in either case, we want to make sure that we're all on the same page, that we're operating under non-disclosure agreements, so that we don't trigger that loss of rights created by the patent laws around the world. And so that's why I have here, public disclosure equals loss of rights. If you take anything home from this, please remember that. It's unfortunately not uncommon that I have to tell an inventor here at that because he or she published, and in the rush to publish, some element of their invention or the invention, that they've now lost the right to be able to pursue a patent application. So that the tech transfer offices are a service office. Like we're there to help people navigate these issues. We don't expect people to be experts in any of the areas that we've just gone through, but it is helpful to know these sort of background steps, to have some idea of the process and what the different avenues that we might use to protect your inventions or other discoveries, so that you can sort of order your affairs and think about that as you're in the grant life cycle and thinking about your publications to think about having that discussion with your tech transfer office so that you can order those affairs as well. And with that, my thanks. I'll probably stop screen sharing here and hope to answer any questions you might have.
Yeah, thank you so much, Zach. That was extremely helpful for me as well. So if anyone has any specific questions, but also we will have office hours to follow up as well, or you can communicate by email. We can set up a meeting with you one-on-one if, as well going forward.
I've got a question. This is Matt here. Zach, a question. It's kind of maybe like a reaction slash question to throw at you. And this is around copywriting. My reaction is around like, the research process is it's always iterative, right? Where you're using this work to build this work to build this work that's led you to this idea. And then with copywriting, you talked a little bit about this with the process, it can't be derivative, I think is the word that you talked about. And so it seems a little bit with faculty members are struggling with this, like I've used this work and this work to kind of build my idea or my process or my product, and trying to like tease that out, like is this derivative, if it is it non-derivative, even though it's based on this whole body of work that's like led me to that point. And we're kind of struggling with that a little bit. And I guess I'm kind of wondering, like, do you just generally see faculty members coming in who like researchers who built their work on others kind of struggling with that, and then maybe just some of the kind of guidance you try and give them to think through that derivative non-derivative decision?
Yeah. No, it's just you, Matt. No, I'm sorry. I'm just kidding.
Yeah.
I think the way I would invite you to think about it is that what comprises copyright, it really just is a very narrow legal concept. And that applies also to this idea of a derivative work. I think a lot of what you're speaking to are the difficulty that some of your colleagues might have, or your peers, which is also very understandable, and I do hear about it. It really comes down to more of this, the idea of what it's more of a scholarly and academic questions about what comprises a substantial enough advancement in a particular field or in an art or some subject to make it, to make it worthy of reporting, right? In other words, it's almost like you're thinking about like what comprises plagiarism, right? Is plagiarism simply the simple, verbatim recitation of somebody else's words? And the answer is no. You can take a paragraph that someone has written, and at least in most higher ed, if you were just to scramble the words and substance and the scholarly substance of that paragraph remains, I think that probably that would be considered as plagiarism, right? You haven't contributed anything, assuming you haven't, cited somebody for those ideas. You're passing them off as your own. That's the element of plagiarism. And so I think I would just be careful to not confuse those. The copyright element, the words creative work is really what's at play here. And so to the extent that you're not looking at someone else's, writings, even, it's like that's not going to be a copyright violation. Like if you're using your own writing style, even if the substance isn't really adding anything, you're not going to be in violation of copyright. I did explain recently to I had someone come to me and say that, like someone's using my copyrighted presentation, and there were elements of the presentation that were certainly the creative works of this person. In fact, that's likely true of my own presentation that I just shared with you. But there are other elements, in fact, many elements that even though she may have drafted them herself, were not creative works, right? Like, I think there was one element where she was providing instructions on how to do a task, like a daily task. And there's just only so many ways that you can describe how to do that. And so it's not the object of the US copyright law to prohibit other people from being able to describe a simple task, right?
Sure.
The object of copyright law is to protect some creative work like an artist, and so that he or she can enjoy some financial exclusivity over that work, but not for people to take vocabulary out of our lexicon or to take ways of, right? So one thing, actually, just to finish my answer, I very commonly hear researchers that have invested their careers, their professional livelihoods in developing data. And they will commonly say, well, this data belongs to me, or I have that I hold a copyright over this data set. That is almost never the case. Generally speaking, data is not copyrightable. It's not a creative work. Generally, data is not protected by any of those 4 pillars of intellectual property that we discussed. Data can be held secret, of course, and that's generally what I advise, university clients that come to me when they're generating data sets. But by virtue of their funding, it may be like an NIH award, for example, that data eventually is going to need to be published, or the journal that they publish it in will require them to publish the data set at the same time that they publish the manuscript. And so, yeah, I'm sorry, I went a little bit off track on your question, but I would think about it very, like there's this very legalistic process for copyright, and try not to confuse that with sort of that same substantive contribution that we think about what makes this valuable academically or scholarly, and how do we distinguish that from what other people have written before us. And the example of plagiarism is sort of is an example that maybe helps make that point clear.
Thanks, Zach. Appreciate it.
I did want to note, and maybe this is a little obvious, but that for our external review board members who are external to our program, they are all going to be required to sign an NDA when they review your applications, for kind of the reasons that Zach mentioned before. So wanted to throw that out there as well.
Yep.
Hi, Zach, this is Mark Gomelski.
Hi, Mark.
Wanted to ask you about trademarks. You didn't have much time to talk about those, but just maybe you can elaborate somewhat on you mentioned that there's a geography aspect to trademarks.
Mm-hmm.
I didn't quite fully understand it. And then perhaps more practical advice from you when a registration of a trademark is worthwhile, and is it a worthwhile at all for a product that does not have a global reach?
Right. Great questions. So I told you that trademark rights, unlike patent rights, exist at what we call common law. And that means when you have a product, a widget, here, I have some chapstick on my desk. It's like, maybe you guys have seen this. It's like Burt's Bees, right? So here's a company called Burt's Bees, and they have, you can't see it, but it has the little circle R. That's their registered trademark right. When they started selling this commercially, like they made it available for sale, they, to the extent that they had sales in the United States, maybe they started, I don't know, it doesn't say here, Durham, North Carolina. So if they started in Durham, they would have trademark rights in that territoriality. One of the greatest, if not the greatest benefit of getting a federal registration with the USPTO on a trademark is that you gain a presumption of territoriality over the entire United States and its possessions, including the space shuttle, by the way. If we have one in orbit, you get trademark rights there. I think there's a case on that. It's pretty cool. Anyway, that's territoriality. So there's common law rights. It's restricted territoriality to the zone of commerce that you're engaging in. But once you have the registration issue from the USPTO, then you gain the total territoriality of the United States. I didn't discuss it, but you can, there are conventions similar to the PCT patent system where you can seek trademark rights in other countries. As with patents, the costs become quite overwhelming. And that's not even the half of it, because that's only to get a trademark or a patent abroad. Now you're left with the question of how do you enforce it abroad? And now you're talking like not just the patent and trademark attorneys like me, but now you're talking like actual litigators, and those guys drive Lamborghinis, right? So like those guys are expensive. So and you know, like in some places of the world, it's just not practical for Americans. You know, like right now, Americans are not having the greatest time having patent rights enforced in China, I think, for obvious reasons. So there are sort of like geopolitical issues also with protecting intellectual property around the world. Your second question was,
I guess, advice. Do you? I mean, when is it worth considering to do a trademark?
Okay, so sorry, a trademark arises by virtue of a commercial act or an offer for sale, and so in many ways, the question of timing with the trademark is not as pressing, certainly not as pressing as with a patent, because it happens on its own, right? Like if you start a company and you start selling widgets or chapstick or whatever it is, it happens on its own. You can't stop it, right? Once there's a product or service that's being offered for sale, and that's a legal term, but it's basically what you think of it is. As soon as you put it on a website or you put a sign on your lawn that says lemonade, you know, like Zach Scott's lemonade stand, that's an offer for sale. There's a price associated with it, and the public at large is sort of, it's available to them. That you have all the elements of a trademark. In the terms of like higher education or you know, small businesses that shoot off of these type of off of universities, like happens here, you know, I would say like that's a conversation you want to have with your own attorney. You know, it may be that it's not the most important thing to do right away, but it's, you know, as your company matures, you're going to want to make sure that you have a source identifier, a company name. If for anything, you just want to make sure that some due diligence has been done so that you're not infringing on someone else's existing trademark rights, right? Like you don't want to name your new company Google, because there's going to be someone that has a problem with that. And you know, that's a funny and very obvious example, but the truth is I've, especially when I was in private practice, these really terrible stories of people investing time and you know, I remember I had a young client who had invested a lot of time on, he had 10,000, he had products and he had put labels on them. He had 10,000 of them. And it was only after he had made those expenditures and that he received a nasty gram from a trademark owner, and it could have been avoided. And he had to, you know, basically start from scratch. He had to relabel 10,000 bottles of his product at great cost, right? And so it is something you want to attend to, but in some ways you just want to do it to make sure that you're not infringing someone else's, and then protect your rights at the same time.
All right, thank you.
Yeah, well, we're at, oh, go ahead, Zach.
I was just gonna say we're at time. Please, you have my email address, I hope, or Caroline will send it out. So I'm always available to, I can give, you know, general advice. I can't give you particularized legal advice, but your tech transfer office or your university's legal counsel may be able to do that for you as it pertains to your university functions.
Yeah. Thanks again, Zach. We really appreciate your time, and good to see you, Matt and Mark, and
Yeah, my
we'll
pleasure.
talk again. See you again next week. All right. Bye,
Yeah.
everyone.
Thanks, Zach. Thanks,
Be
Caroline.
well.
Bye, all.